Hello and welcome to Justice Speaks. My name is Mac Jenkins. I am a retired Chief Probation Officer from California and Vice President at Justice Speakers Institute. We're continuing a new approach of interviewing justice leaders to get their perspective on the current state of the justice system and where they think it should be going. Some of these leaders you may know or have heard of, and some you haven't. All of them, whether educators, practitioners, or observers of the justice system, will give you as listeners a better understanding of how the justice system works and where it's going. And with that, I'd like to introduce the Honorable Judge Stephen Manley, who is a leader in the collaborative court movement here in the state of California. Welcome, Judge Manley.
Thank you. Glad to be here.
Cool. Well, my first question is, tell the listeners a little bit about yourself.
Well, I'm a Superior Court judge in California, and I've been a judge for over 30 years. And after spending the early part of my career in many areas, including criminal law, I started one of the early drug courts in the nation and have gone on to work in collaborative courts for the balance of my career in the courts. And so in doing that, I spent a lot of time in working with policymakers, because we always have a challenge in California. We're usually very far ahead of anyone else, or we're very far behind of everyone else. But the important thing to understand about California, I think, is that policy can be made by the voters through the initiative process. It can be made by the legislature, it can be made by the governor. And because we have those three groups, two separate branches of government, and the voters themselves setting policy, it changes quite dramatically over time. Mm-hmm. And I have always felt, as I did years ago, that our main challenge is to adjust what we are doing to meet the policy mandates that are given to us, and to try and make programs that the legislature and the governor develop to be effective. For example, a number of years ago, the legislature passed a bill that I was involved in from the beginning, because it was a need we have to create reentry courts for individuals at that time coming out of prison or coming out of jail. But the primary focus was on those who were the highest risk individuals on parole, who had already violated the conditions of their parole, usually by using drugs or committing a new offense. And they, as a part of the violation process in California, the parole agents have a script they must follow. There are sanctions that they can impose or not impose. They have to document everything. But the last sanction that is available to them, other than incarcerating the individual, it would be to send them to a reentry court. So what we did is we worked very hard. Our system at that time was structured in a way, if you were on parole and you violated your parole by using drugs while on parole, which is the condition you can, or you did not go to meet with your parole agent, then you would be sent back to prison, and the parole board, which operated outside of the courts, determined what your punishment would be, because it was always punishment. And I saw and noted that what was happening was that the individuals were getting 1 extra year in state prison, instead of having a meaningful process where the individual would be sanctioned in some way and then put back into the community and given some extra help. And I thought it was atrocious. And actually, parole violations led to the sanctions for parole violations, led to the overcrowding of our prisons, mm-hmm. which led to lawsuits. We had more people in prison than anywhere in the country.
176,000.
Right, right. 176,000 people, and that was not driven by new crimes or judges sending everybody to prison. It was primarily driven by individuals who, it's mandatory that you be on parole 3 years. If you violate your parole, you went back to prison. And so that jumped the numbers way over where they should be. And my thought was, if you used a reentry court and put into effect a sanction, parole would look at this as a sanction, because they're required to go through certain interventions with the parolee. And I said, well, let's stop the intervention of now we're going to just send this to the court or send this to the parole, the parole board. At that time, originally, it was the parole board. And I said, rather, let's try and intervene and do something in a treatment court model. And that's what I did. And what happened was, I spent most of my time trying to convince the parole board not to, because they still had the ultimate decision. Sure. I had no power whatsoever. The Secretary of Corrections at that time permitted this pilot project to go on in our county only and in our court only, because basically a Superior Court judge doesn't have any power at all at that time over a parolee. And go ahead.
It's because already our listeners can hear from just what you've said so far how Judge Manley has been influential in some significant criminal justice trends in this state. So don't lose your point there, but I want to go back though, and I want to hear a little bit more of what even drew you to the whole collaborative court approach in the first place. Because you said you've been a judge for 30 years.
Right.
And we know drug courts themselves started in 1989, and here in California you get arguments about when they first appeared. But what was your draw? What drew you first to that? Why did you want to, you're
Sure.
What was your interest there?
Well, my interest was really a concern, because I early on in my career, I was sentencing many people, and many of them are being sentenced to prison or lengthy jail sentences. And what I noted at that time, and I remember how, because I sat down and I kept a list of what happened to these individuals, because what struck me is suddenly I was seeing their sons or daughters or their nephew or their father or their grandfather, and I was saying, wait a minute, why are we continuing this again and again and again to just use this one alternative of punishment to try and get people to change their behavior, when we know, I mean, it was very clear to me that it did not work. Because when I first started, as a judge, you're trying to be reasonable, to be fair. I was trying to show some compassion, and at the same time hold people accountable. These are a lot of different challenges for a judge in reviewing someone who comes before the judge. And I just saw that our plate of alternatives was zero. It was empty. There was nothing there. So my thought was, we have to be more creative here. And so one of the very first things I did after starting the drug court is I fully understood that we needed funding, that we were not going to be able to survive on grants from BJA or SAMHSA or anywhere else, and particularly because at that time the mandate was you could not take a violent offender. I mean, and it's still true today as to BJA. So you couldn't even apply for the grants if you wanted to work with hardcore individuals who were really struggling. And so I said what we needed was state funding, and we were able to, with a lot of hard work, a number of judges, really compassionate, caring judges who really wanted to help people get better. We were able to convince the policy committee and then the appropriations committee in the legislature to fund treatment in the drug courts in California, because I had another concept in my mind at all times, and that was, number one, you need funding, as I've already said, but number two, we always think of, well, what will incentivize the individual to change their behavior? But my thought was, what incentivizes the judges to change their behavior and be willing to do this? Because when I first started doing this in my court, people would say, well, you're just a social worker, not a judge. I mean, and you say, all right, well, fine, that's your view. But to me it was, well, why do you have to keep that view? How can we work to get you to change that view? And my view, my personal philosophy was, I have to show them that this program works, or they're not going to change their mind. So then it occurred to me, what does motivate the courts, the third branch of government? And what motivates the courts, in my view, at that time, was funding. Because there were hard years. Why would a presiding judge say, well, let's start drug court when I don't have enough money and enough judges to do my mandated functions, and you want me to do something special and new, and you think it's exciting and meaningful, but I don't have the resources. But if you put out funding and you say, if you accept this funding, you must do X, then I think you get an entirely different reaction and answer from the courts at that time. Now, things change, but at that time, we really were strapped for funding in the courts.
But you were successful, though, were you
Yes,
not here in
that
California?
worked.
And in fact, I want to talk a little bit about the association now, the California Collaborative Courts Association, if I say that correctly. So what,
Right.
first thing first, what's your title in the association? Are you president, or
I'm
what's
the
your
president of the board of directors, or chair of the board of directors, president of the association.
And how long have you been in that position?
Wow, probably over 20 years.
So tell us a
They
little
don't
bit
get
about
rid
the
of me.
association, because I've been active in the association
Right.
myself, but tell us a little bit about the association from its creation, because we just heard you say that you, after wanting to start your own drug court, recognized that the court needed money, and you led an effort, or were key in an effort, to get the legislature to fund drug court treatment. So tell us about your efforts in helping to start the association.
Well, the efforts were basically, in the beginning, there were very few of us. There were not, I think, as I recall, in the room, there may have been 50, 40 people. And that was when it was very exciting to do this. And the reason was because NADCP, in their wisdom at that time, felt that we should create a Congress of state drug court associations, which we created. And so when it came to California, we had, there was going to be the NADCP conference was going to be in California. And so at that conference, we formed our association. We actually had done a lot of work beforehand. It was very chaotic to put that all together, and we formed the association. And the purpose of the association was basically to be involved in policy. That was really the beginning, because there were, even in the earliest days, there were a lot of naysayers, of course, a lot of policymakers who didn't believe that what we were doing was even worth thinking about, let alone trying. Even though we're in California, and we have in our court system, of course, similar, I presume, to many others, is not controlled by the Judicial Council. So the third branch of government is basically the Judicial Council, but each of our 58 trial courts operates separately, and they have their own budget. And therefore, if you're going to try to bring all these people together with so many different views about what a drug court should be, you ought to try to have an association, one, to work on policy, and number two, to work on providing education, training and treatment, in treatment, and best practices, and all the other things that we do today. But in the early years, it was basically surviving to the next year and working on policy, and then we started putting on conferences.
Does the association have membership? Are there
Yes,
members?
we do.
Do you know the rough number?
No, I do not offhand, because I haven't seen the numbers from this conference as to how many more people have joined. What we have always tried to do is keep the cost of membership in our association at the bare minimum. similar to what NADCP did in the beginning, where I think it was $15 or $20. And we've kept our membership fees very low, because I learned in working with NADCP that the real effort here has to be by a very few individuals. You need people to organize volunteers, but to sustain effort over a long period of time in a voluntary organization with no paid staff is really difficult.
Absolutely.
And so you have to focus on what can you do. And we just determined that because we have 58 counties, 58 different trial courts, no one ever does things exactly the same as in the next county. So you're from Orange County. I know Orange County's collaborative courts very well, and they're very different from ours.
Right.
And they're going to be very different from San Mateo or any of the other counties, you know. And so the size is not always the determinant. The determinant is really the people who are putting this court concept of treatment into action. And so it gets implemented in different ways. And so what we came down to is saying, well, we ought to have conferences as often as we can. And at those conferences, we can show everyone in California who's doing our work how's the best way to do it, what are some new ideas to think about. You know, we can't assume that everyone, prior to the pandemic, during the pandemic, of course, you could go on Zoom or
Right.
WebEx or any of them and see one presentation after another. But in the beginning, you know, there's nobody to do that for you. We didn't have remote technology. So it was these personal encounters at a conference where the idea was come there, learn, and then meet together as your team. Encourage teams to come to conferences, just as we have this year.
And if I may too, because you just mentioned, so the association's been in existence roughly 20 years, because you've been the only president. Am I correct?
No, we had a president, Tomar Mason, wonderful
that's
judge
right.
from San Francisco,
Forgot
was the
about that.
first president.
But has there been a conference every year? My recollection is there hasn't been.
No. The conferences, in the beginning, we were, you know, the challenge with conferences is really, again, what I started with the challenge with judges, it's funding.
Right.
And, you know, we're a nonprofit organization. We have no source of income other than membership fees. And when you keep your membership fees low to encourage more people to join, you really can't count on that as a revenue source. So we started then reaching out to our partners in the community, our justice partners, our treatment partners, and have them make presentations at conferences, you know, where we did not have to expend a lot of money. And I can recall association conferences, I remember so clearly because it happened at this conference. In the morning, we ran out of coffee. Now, at this year, when we run out of coffee, we just order more, because we learned that coffee is really important to people, especially when they have to start at 7:30 or 8 in the morning in a session.
I can see that.
You got to have coffee. Well, no problem today, but back then we didn't have the money, so I had to tell everyone at the conference, very sorry, but there's no more coffee. And, you know, that makes it very, very difficult. And so, you know, from then we've grown, and now we're able to put on a conference such as the one we've just held with the largest number of people we have ever had at a conference. You know, another challenge in California is we are a very large state, and traveling is very difficult.
Right.
For many people, and you know, the courts are always, in my view, have been for years underfunded. They continue to be underfunded. And therefore, it's really hard for judges to necessarily walk away from their calendars, depending on what court they're in. You know, if you're in a very large court, a large court like mine even, you can have another judge take your place. But in smaller courts, that's often not an option.
Right.
Nor is it for district attorneys or public defenders in a you know, mid-sized or smaller court, or in a program or a court where their bosses do not favor this kind of exposure to learning new and different ways to approach issues. So that we have really been working hard to try and change that, and that's, that really takes a change in the thinking of the leadership of the courts. And that's the reason why I'm so happy at this conference. In our first opening session, we had 2 presiding judges and 2 district attorneys. Because it's often thought, and it's expressed, and it's probably often true, that you can't get anywhere if you want to do a collaborative court without the permission of the presiding judge or the approval of the entire bench. And presiding judges say no, because I have been a presiding judge many years ago. I would never do it again. It is a very hard job. I thank every presiding judge who ever takes that on.
Well, I think that's a significant point. So at that this conference, you had 2 presiding judges, 2 elected DAs, I'm hearing. So was that, what was the reason for that success? Was that because Judge Manley reached out and there was the power of Judge Manley getting those people there? Or what got them here?
No, I think what's happened, what we're coming to see is there's been a dramatic change in thinking about problems and issues and how to solve them in the criminal justice system and all our other systems, whether it be juvenile. And the reason that there has to be a change is because state policy in California is moving more and more to placing responsibility at the local level in the counties. Mm-hmm. And when you shift from a state-run system, whether it's our prisons, we are closing prisons, and we are saying to judges, and to the public, that the ultimate sanction here will be imprisonment in the county jail for a number of years. And of course, once you change that discussion to one about, we're going to move everything down with you at the local level, then the local level has to become more involved, because it's their destiny that's being decided in the legislature. And I think what happens is that over time, district attorneys, not all of them, and it will never be all of them, public defenders who often are not that enthusiastic about treatment courts because they ask too much, they give too little, and they beat up on people. And I fully understand that, because we started out to be really sanction driven in the early days, if you recall. I mean, even at this conference, the idea of one dirty drug test is 1 day in jail, I mean, it just doesn't work. And California is changed, the policymakers are way ahead, and they're really moving in the direction of things like deflection. Right. Which you and I have discussed.
You and I have had long conversations.
And we're in my own county, this is, the driving factor is we do not want to rebuild or build another jail. We have reduced the population, we want to keep it down, and we look to the courts I mean, obviously they can't tell judges what to do, but where are they looking for? The judges hold the keys to the jail. I mean, we either put people in or we let them out.
And we're running short on time.
Okay.
I want to ask you
I'm sorry.
No. I know that there's a lot that Judge Manley has to say, but I want to ask you at least 2 other questions before we stop. And one of them is, and the listeners may not appreciate this, but you and I certainly know this, that there have been legal changes in California that have reduced penalties for drug possession offenses and things along those lines. And I want your take on that impact on drug court populations particularly, and just what your thoughts are. I'm talking about Prop 47.
Sure.
You and I know
we've had as I said, voters decide how things are done in California, and we had an initiative that basically took away much of the criminal sanctioning for possession or use of drugs.
So how should the courts in California look to that? And in your experience, how have they responded to that?
Well, in my view, and what I've tried to do and encourage, and what we're encouraging at this conference, is to start doing what you should have done in the first place, which is take those more difficult clients, those individuals charged with serious felonies. We hide from all these groups. We say, we won't take, it's gang affiliated or it's sex. Well, I can tell you that sex offenders, arson offenders have to register. If they don't register, depending on where they fall, and the legislature is trying to make it easier, they end up with mandatory jail. And, well, all over not registering. So why aren't you trying to do something about this? See, I believe that courts have an obligation to be part of the solution instead of continuing the problem and making it worse. So what I'm trying to do is encourage this whole change to working with the very serious offenders, very serious charges, incredible needs.
Okay.
And I think the challenge there is convincing other judges and district attorneys that this works, because it does work.
All right, so we've got about 2 minutes left.
All right.
So I want to know, Judge Manley, because the other thing that you've been really a powerful mover behind is something called care courts. So in about 1 minute and 45 seconds, can you capture what care courts are about?
Care courts are really about taking those individuals in our communities who are the least able to care for themselves, the least able to access treatment, and the most resistant to ever being in treatment, to ever take medications. And these are people who, in simple English, are psychotic. They hear voices. They have a perception of reality that is entirely different from ours. When you talk to them, and I talk to them every day of the week, they are not with me in our discussion. They tell me that I'm nobody to shut up, and they are God, they are Jesus Christ, they are the CIA, whatever. And these individuals are very difficult to work with. Well, what care court's all about is, look, let's see if we can't change the behavior and the lives and help people who are the least able to help themselves. And the way we're going to do that is give relatives and family members the right to come directly to court and ask for a hearing. Then we're going to have a hearing. We're going to have behavioral health mandated to be involved, and we're going to put a great deal of money in this, and it must be civil, because in California, no longer does anyone like the word criminal. So it has to be civil. And then we are going to fund the most critical part of this: housing, treatment. It's all going to be funded by the state.
Okay, unfortunately, we're probably going to have a second interview with you, Judge Manley, because we're going to have to leave it there.
All right.
But I really want to thank you for the time and for all that you've shared with our listeners. So thank you very much.
Glad to do it. Thank you, Matt.
Absolutely.